Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Breaking news with Kirk Pendergrass and Chris Hallett. You're on.
Good morning, afternoon, wherever you're at. It's 20 minutes to noon here, so it's before noon for me. It's those of you on further east, it's afternoon for you. So thank you, Chris Hallett, for joining us today.
Absolutely.
Serious breaking news, folks. Okay, the rule of law is being laid down, smacked down. Okay, the Attorney General for the United States of America, Jeff Sessions, went live yesterday. Not only did he go live and talk about it, but he put out a memorandum for all components from the Attorney General, dated November 16th, 2017. This is yesterday. That's why this is breaking news. The subject matter is prohibition on improper guidance documents. Essentially what this means is going back to Title 70, Idaho Code, Title 74, Section 201, which specifically says the people of the state of Idaho do not yield their sovereignty to the agencies so created. But this subject is talking about the improper guidance documents, is the agencies, the executive branch, acting outside of the rule of law and creating these guidance documents within their own agency, applying it to their agents, telling them that they can do what they want to do, which is outside the rule of law. And Jeff Sessions did the smackdown on this. So we're going to play the video. We're going to play parts of it. This isn't cut and pasted, clipped, or nothing like that. This is going to be played in its entirety. We're not picking pieces and parts here. So you can actually watch and listen as it's being played, and we'll stop it, and then we're going to talk about certain parts of what he's saying. And then I'm going to go over this letter, this memorandum for all components put out by the Office of the Attorney General, Washington, D.C., November 16th, 2017.
No cabinet secretary has the power, through guidance, letters, or otherwise, to wipe out entire sections of the immigration law. But that's what the previous administration did with its deferred action for childhood arrivals, or DACA policy. Under DACA, without the consent of Congress, individuals here illegally who met certain criteria were granted not only lawful presence, but the work authorization and the right to participate in Social Security, which unlawful immigrants are not entitled to have. So no matter what one thinks about the immigration issues and policy, it cannot be defended, in my opinion, lawfully. So once again, the department advised and the administration put an end to it. And it's been ended. It's being ended now. The department is also restoring the rule of law through litigation. Our Solicitor General, Noel Francisco, who I don't know. Yes, he's right. He's a member of this group. One of a very, very long time. The department is also restoring the rule of law through litigation. The Solicitor General has filed an amicus brief in support of the Colorado baker who was sued for refusing to bake a cake for a same-sex wedding. Although public accommodation laws serve important purposes, they, like other laws, cannot be interpreted to undermine individual freedoms guaranteed by the First Amendment. That includes the freedom not to provide creative expression for ceremonies that violate one's religious beliefs. So meanwhile, I've changed.
Okay, so if those people out there are aware of the case that happened when a bakery who makes cakes was forced to make this cake for a gay marriage, who says, well, you're a business, I have the right to buy a cake from you, and I'm going to force you to do that. No, the rule of law says no. You have the right to contract your labor as you see fit, uninhibited by any statutes, rules, and regulations. This is what we're getting at here, the rule of law. And what I talked about last night on Law for Dummies was you can't exercise a right over the top of my rights, period. So I have the right to contract my labor, if I was the baker, with anyone who I choose. This is where the right to refuse service to anyone for any reason. I don't have to give you a reason why. If I'm refusing my services to you, you don't have a right to a cause of action because you don't have the right to demand that I do something for you, that I contract with you. You can't force me into a contract. That's unlawful. That's use of force. And then to try and take me to court and say, well, you violated my rights. No, that's not how the rule of law works. And this is the smackdown that's coming. The changes that are coming through that executive order that we were talking about, that I posted all over the place yesterday. And then I found this video last night. So let's continue with rolling the video.
Policies at the department that support our mission of doing justice by executing the law. For example, we are no longer allowing so-called sanctuary city jurisdictions to nullify federal immigration law if they want to receive discretionary grants. We have placed conditions on these grants to encourage our elected leaders of these states and cities to comply with minimal cooperative requirements to assist in removing criminal aliens from the country. In June, I ended the practice of third-party settlements. Under the last administration, the Justice Department often required settling parties to pay settlement funds to third-party organizations that were not directly involved in the litigation or harmed by the defendant's conduct. We believe that when the federal government settles a case against a corporate wrongdoer, any settlement funds should go first to the victims and then to the United States Treasury, not the bankroll.
So right there, what he's actually caught these people doing is when they do the settlement, is they're actually taking the settlement money and they're paying the victims, but then the leftover money goes into the International Monetary Fund, basically, and not in the United States Treasury where it is supposed to go. That's fraud upon the people, because that leftover money is supposed to be paid to us, we the people. That means it's supposed to go into the Treasury, not into the International Monetary Fund, so that they can play with it how they want instead of our money. All right, let's continue rolling that.
It's not the bankroll, third-party, special interest groups, or the political friends, or whoever is in power. Nowhere does the Constitution grant unelected attorneys, even DOJ, wonderful sainted attorneys, or political appointees, the power to effectively appropriate and distribute United States Treasury funds based on political alliances and friendships. Neither does it give them the power to issue regulations outside the process of Congress's regulatory authorities given by Congress. Too often, Rather than going through the long, slow regulatory process provided in statute, agencies make new rules through guidance documents by simply sending out a letter. This cuts off the public from the regulatory process by skipping the required public hearings and comment periods, and it is simply not what these documents are for. Guidance documents should be used reasonably to explain existing law, not to change it or rewrite the law. From now on, at the Department of Justice, that's what we're going to do. I'm announcing today this process is over.
Okay, there's the key words. This process is now over. That's what this subject matter is on this Office of the Attorney General memorandum for all components. Okay? The Department of Justice has the duty to uphold the laws of the United States and to ensure the fair and impartial administration of justice. Therefore, when departments engages in regulatory activity, it should model the lawful exercise of regulatory power. Okay? In promulgating regulations, the department must abide by constitutional principles and follow the rules imposed by Congress and the President. Okay? These principles rules include the fundamental requirement that agencies regulate only within the authority delegated to them by Congress, by we the people, because we are Congress. Okay? They also include the Administrative Procedure Act's requirements to use, in most cases, notice and comment rulemaking when purporting to create rights or obligations binding on members of the public or the agency. Okay? So what he's talking about is they're promulgating these guidance documents and they're misapplying the rule of law by creating these policies, and we're all aware of these policies. Well, the policy says, well, the law says something totally different, and you can't do that. That's subversion. That's subverting the law, and that is unlawful. And so that's what he just put the kibosh on yesterday, as of November 16th, 2017. That's done. So if you have and are aware of an agency that is promulgating these things without lawful authority and their policy is different than the law, guess what? You're in violation of this right here. You're in violation of the rule of law. So let's see, what else does it say here to the members of the agency? Not only is notice and comment rulemaking generally required by law, Title 74, Section 201 actually goes into that no law is to be made. It's supposed to be in open meetings. That's the hearings that he's talking about. By law, they're supposed to have a public hearing regarding this guidance documents. And then the rulemaking of the policy of the agency is supposed to be open to the public for public hearing and public comment. And this is being subverted. Our rights to object to their policies, again, the people of the state of Idaho do not yield their sovereignty to the agency so created. By consent only. That's a constitutional republic. By the public. For the public. Okay? We have the power to say, no, you can't do that. That's unlawful. And that's exactly what we're talking about when President Trump says putting the power back into the people. All of this stuff that's been done in secret without our consent, without our ability to hear it before it's implemented, it is unlawful. And now has been obviously looked into, and it's being observed, and it's been found out that this is what's actually going on, and is now prohibited. I mean, I don't understand why we have to say that it's prohibited. This should be common sense. So, yeah, let's continue rolling because there's lots of more good stuff here.
So we prohibited all Department of Justice components from issuing any guidance that purports to impose new obligations on any party outside the executive branch. We will review and repeal existing guidance documents that violate this common sense principle. We will also now honor a directive that has been on the books at the Department of Justice since it was ordained by the man sitting at my right, Ed Meese, when he was Attorney General. I am ending regulation by litigation. The days of sue and settle, when special interests could sue an agency, then get the agency to agree to a settlement to impose, in effect, a new regulation to advance an agenda, is over.
That is over. That is over.
The Department of Justice is duty-bound to defend laws as they are written, regardless of whether or not the government likes the results. Our agencies must follow law. We're not entitled to make it. Judges in our courts must apply it. But as we know too well, some judges fail to respect Congress and the executive branch. One particularly striking example, it's a bit in my craw, I'll admit, was a federal judge in Brooklyn who heard arguments on a challenge to the federal government's wind down of the DACA. Outside the legal question, the court said to the government, to our government counsel, you can't come into court to espouse a position that is so heartless, close quote. Not unlawful, heartless. With respect, it is the province and duty of the court to say what the law is. I knew you'd get that.
Okay, so you just heard the leading top attorney for the United States of America just say that the Justice Department is supposed to, what, uphold the law as it is written, exactly what it says. And what have I been saying for over a year? The law says what it says, and it doesn't say what it doesn't say. So this is why I go back to, you got to read what the law says so that you can effectively claim what it says and hold it up and say, judicial notice, Your Honor, this is what it says. We hold these truths to be self-evident, that all men are created equal, that all are endowed by their Creator with certain unalienable rights, are endowed by their Creator, not the government, not your fellow man, because this is something I want to get out there. From now on, when you say government, I want you to change that word and say your neighbor, because that's what government is. It is your neighbor. Again, we are self-governed. This is not a communist regime, although that's what it's acting like. We need to take back our political power and say, wait a minute here. Here's the rule of law. You don't have that authority. That's an usurpation of power. That's treason. Okay? Right there. That's what the law says. Okay? Declaration of Independence. Read it. That's the rule of law. Chris, you got anything to add to that?
Make sure he's unmuted.
Oh, I had him on mute because his microphone was making so much noise over there.
I think he muted himself.
Yeah, welcome back.
Welcome back, Cotta.
Yeah, I'm just sitting here giggling at the implications of what Jeff Sessions just removed from these agencies.
Right?
So, it's like, at the risk of sounding like a broken freaking record, pretty much what you just got done saying, this is what happens when you ask the right question instead of standing there running off at the mouth like we've been hearing pretty much across the board. So I just had to add, I thought that was hilarious. But anyway, continue.
But you know what's funny here is, I've been attacked, and attacked for saying what I'm saying is, oh, well, where's your proof? And I'm like, why don't you pay attention? Because I read the law, what it says, okay? So, again, back to what he just said, Jeff Sessions says, that's the rule of law. And the judges are supposed to uphold what the law says. So don't attack me for what I'm reading straight out of a frickin' book. Okay? You're going to lose that argument every time. Let's continue rolling the video.
They are to apply and follow the law, not advance an ideology or express political beliefs. And we cannot allow unelected judges to set policy through an abuse of the adjudicative process. Comments on policy like these from a judge are offensive. They unfairly criticize an attorney who is effectively doing his job. Judges have the solemn responsibility to examine the law impartially. We're going to resist this tendency resolutely. The judicial branch is a co-equal branch. It is not a superior or a policy-setting branch. It needs to know its role.
Right.
Beautiful.
The judicial branch is not a policy-making branch of the government. Imagine that. Your stare decisis, all your case law, because that stare decisis is Latin for, that's what the case law is. And people like to claim that that's the common law. That is not the common law. As I read yesterday from American jurisprudence, our rights are the common law. Bills of rights are the common law. Declarations are the common law. The Constitution is the common law. Okay? That's what common law is. And that falls under constitutional law, which is outside of government. This is constitutional law, a separate jurisdiction, okay? We don't really have suits at constitutional law. We have suits at the common law. When we talk about the suits at law in Article 3, that's the common law. And then you go to the 7th Amendment, which says suits at the common law exceeding $20, the value of $20. The right to a trial by jury shall be preserved. Okay, that ties to Article 3. Suits at the common law and suits of equity are the only two jurisdictions lawfully allowed on the land, the common law. We, the people, live at the common law. Our rights are the common law, not statutory law. And as I read yesterday, there we go again, American jurisprudence, constitutional law, when there's a statement in a constitution or a declaration that is self-executing. We do not need, there's no delegation of power to the legislative branch to create statutory law regarding that self-executing part. And going back to what Jeff Sessions just said, it says what it says. That's a fact of law. That is the rule of law. It imposes a duty on your fellow man to obey that as it is written, not how you interpret it, not how you think it is, or how you feel it is, like Jeff Sessions just said. Not about feelings here. This is the rule of law, and it says what it says. Okay, so statutory law is not designed to create law. It is supposed to codify the law, or codify, however you want to say it. That's the way it is. That's in accordance with constitutional law. There's no authority for the legislative branch to act outside its properly delegated authority or limitations. That would be the 9th Amendment and the 10th Amendment specifically. The powers not delegated here in this Constitution is prohibited to the federal government and to the states, unless it's not listed here. So that's why you have to read the Constitution. That's why you have to read what your rights are, the bills of rights that are out there. not just the Bill of Rights. It says bills of rights, which is plural, more than one. And just so we're aware here, I know I kind of showed this before, but here's the actual original Bill of Rights containing all 12 articles of the Bill of Rights. That's right, 12. Okay, the first 2 were not actually ratified. So what we actually have is 3 through 12 as the first 10 articles. And so what we need to understand about this Bill of Rights is that this is, where is it? The Constitution aforementioned of the states having it, where is it? Articles in addition to. These are articles in addition to the Constitution. Okay? This isn't just an amendment to the Constitution, because what part of the Constitution are they amending? None. What this is actually is articles in addition to. When we say Article 1, Article 2, Article 3, Article 4, Article 5, Article 6, and 7, this is a separate set of articles in addition to the Constitution. As an amendment to the Constitution, okay, these are bills of rights. This is actually have the certificate of authenticity on this. Okay, and if you can kind of see that parchment paper that it's written on, this is actually a pretty cool document. So again, back to understanding what your rights are, where they come from in law, and how to effectively claim those rights and defend those rights requires you to read what it says so that you can effectively claim it where it comes from in law. And the rule of law says the judges are supposed to uphold what it says, not what they think. They don't have the right to interpret it because it's self-executing. It says what it says, and it doesn't say what it doesn't say. So, Chris, anything to add to that?
Well, I think it is definitely going to lead into my historical explanation of the Parens Patriae doctrine, which we will do on our next show. But because it all ties together. And what it boils down to is, when you're talking about your children, that doctrine was created to, quote unquote, deal with children who didn't have proper parentage or lineage, right? Typically born out of wedlock, when, men would go wenching, that's what they used to call it, and they would pick up a streetwalker, a hooker, and a kid would be born. Well, that kid was called a bastard child. That's where that name came from.
Right.
And those children were given to the church under the doctrine of Parens Patriae, right? And the church was responsible for them.
Now let me
when that doctrine came over here,
Chris,
go ahead.
Let me add just this right here. Now, under bastard child, that means that the father has not claimed the child. Just so we clarify the difference between a bastard child. Because what this is a child that's born out of wedlock. Okay?
Mm-hmm.
So when a child is born out of wedlock, the father has to claim the child by affidavit. Right. This is the guise they come under with the birth certificate. If you read it, it's actually an affidavit. Right at the top, it says affidavit. Okay? So if you're the father of a child born out of wedlock, if you do your affidavit that you're claiming the child is not a bastard child. So go ahead.
Correct. In other words, the doctrine of Parens Patriae does not apply. Right?
Bingo.
So anybody who has children who was married, you can claim you can claim they don't have personal jurisdiction over you, because those children were born under a legitimate marriage. So there's another piece to the argument a lot of people don't even know that they can make. So this is where knowing your history comes into play. So anyway, that's the reason that the doctrine of parens patriae became so blown out of proportion, was they misapplied the law. They didn't have standing or personal jurisdiction to apply that doctrine in many of these cases, especially everyone where the mother and father were married, right? The parens patriae doctrine doesn't even apply to that. It cannot be invoked. Same thing with the best interest doctrine, right? Because those two go hand in hand.
Brian, I'm going to have you on here in a second.
So when it comes to the, how all of these mechanisms work, that's when you say, say it. Go walk into court and say, look, you're applying this, this, and this, but you don't have personal jurisdiction to apply it. And here's why. And here's the history why.
Yep.
And there's no argument for that. So anyway, apparently we've got a caller, so go ahead and take the caller.
Yep.
I'm going to go back to mute because I'm going to make some noise.
Okay. Yep. Brian?
How you doing?
Pretty good, sir. How are you doing?
Hey, it's the middle of the day. I can join you.
Right? It looks like you're driving right now.
I got my headset.
Right?
I'm on my way to St. Paul, Minnesota.
Right on. So you've been listening in? You catch what's going on here?
I just joined in, so I missed something important he was talking about, but the final thing he talked about, the best interest doctrine. I looked into that best interest doctrine, and that doctrine itself is unconstitutional because it is pure speculation.
Well, no. I've done the research on the best interest of the child doctrine, and it is lawful. We cannot attack. Okay, so basically, the best interest of the child doctrine is very simple. Let's go back to neighbor instead of saying government. I'm going to start saying your neighbor. So I'm your neighbor. You're out here playing in the yard with your kids, and I watch you go over and smack the crap out of your kid. Okay, now I have the right to go over there and stop that. Okay?
Now that's
basically what the best interest of the child is.
That is good application, but the problem is in today's times that's not how it's applied. It is based on pure speculation when it comes to government intervention in families. It is what they deem the best interest. So they use that doctrine, and they even use it in most cases outside of its purview. As in, they use it, it's supposed to only be used once neglect or abuse is proven. They don't do that. They use it during the fact finding.
So the question is the rule of law being followed, or is it being subverted by guidance documents? Because that's what this is about. The guidance documents that the agency, Child Protective Service, puts out and tells their agents that they can do this, which is subversion of the law and their policy, they're not following the best interest of the child doctrine. They're not following the legislative intent of implication of. And now Chris Hallett could say the exact words what that really is, but it's misrepresentation of the statute? He's got the correct term down there.
For which one, Kirk?
Okay, so where the legislative intent, the statute says this is the procedure that this is supposed to happen, and then through this guidance documents, the agency says their agents can do this outside of the legislative intent. What is that actual lawful legal term called?
The actual legal term for that is called an emolument.
Well, no, wait a minute. Isn't it malfeasance?
Well, malfeasance is the action. The benefit or gain that they receive by doing it is the emolument.
Right. But I'm not talking about the emoluments. What I'm talking about is the statute says one thing, and the agency and the agents of the agency are doing something different than what the statute says.
Misappropriation.
Correct. So that's, you can call it whatever you want. Malfeasance of office.
No, there's an actual legal term for that, and I can't remember exactly what it is. It's not misprision.
Well, ask 10 people, and all 10 of them will probably tell you treason. But
well, treason
that's
would be
another whole argument.
That's outside.
Well, one of the things it is abuse of process. It's also color of law. There's all kinds of
but there's a specific term.
Well, there's a difference between color of law and color of authority. What they've been using is color of authority. And it's an authority not granted to them. It was one that they usurped the Constitution and took, which was the basis for my monopoly argument.
Right.
You see how that all worked out?
I mean, I totally agree that it's an emolument. It's a violation.
Now, I'm presuming that the monopoly argument might be on the breaking story with AT&T and Time Warner.
Yep. And that's pretty much what I said. I said, I walked in there and said, look, if I can't hold a monopoly over telecommunications, you can't hold a monopoly over the practice of law. And they said, oh, man. And that's exactly what they've been doing. They've been behaving as a monopoly, a bilateral monopoly, but a monopoly nonetheless. So it's all in how you make the argument. So we agreed to disagree that, okay, you're right. We're not going to admit it, but you're right. So go back to the district court and tell us exactly what you're talking about.
Right.
Well, that's when I filed my emoluments violations complaint. And now you see what happens when you ask the right question after 230 years. So, because nobody's ever defined what the hell an emolument is.
Right.
Well, it's not what you say, it's always how you say it.
How you say it. Right. Exactly. So
you have to make your arguments. So
I said, okay, bring us an example of what you think an emolument is. So I said, well, the monopoly is one. And because they've allowed me to practice, well, then they said, okay, we've agreed to disagree on that. Here's practice. Go ahead, have at it.
Well,
so
here's the problem. The Supreme Court has ruled in numerous occasions when it comes to the practice of law that you can't license it. Mm-hmm. It's basically the short version. Each individual is right, especially
exactly.
If they want
it's a right retained
free.
Right, it's a right retained by the people.
Misapplication of the law, John Patton. I think that's the phrase. Misapplication of the law.
Yeah, you talking about my report, Kirk?
No, I'm the John Patton here. I'm looking for that phrase. It's misapplication of the law. The statute says one thing, and the agency, through these guidance documents, tell their agents that they can do it this way, which is subversion of the law. Now, back to what you were saying there in emoluments. See, this is the thing: this is actually constitutional law that emoluments falls under, because it's Article 1, Section 9, Clause 8. And it says, no title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of Congress, accept any present, emolument, office, or title of any kind whatsoever from any king, prince, or foreign state. Okay? But the emolument part is what actually is our tax dollars paying this in public servant. Either you're an elected official or you're appointed into a position of public trust. So when they are paid with tax dollars, that's an emolument. Okay. Now, what constitutes the emolument violations is in the exercise of your duty, that job description, okay, your moral duties and ethical obligations under your position, either of an elected official or in a position of public trust, because that's the only two types of public servants we have, okay, in your official capacity, performing your moral duties and ethical obligations under the law. under the law, and you fail to perform your duties under the rule of law, that is an unjust enrichment. That is an emolument violation.
I have to play devil's advocate for a second.
Okay.
If it was operating as a Republican form of government, I would have to say you're right. But it's not. It is a corporation, and that is defined in U.S. Code. That was since the 1871 District of Columbia Organic Act.
Right, which is unlawful because Congress can't do that. There's no delegation with show me in the Constitution. You just usurped the supreme law of the land.
Right.
Yeah.
Marbury versus Madison, that's null and void from its inception. Sorry, bye. That's not in the rule of law.
Which is why they've danced around the word emolument for 230 years.
Right. All of those members of Congress that signed and agreed and voted to pass that act committed capital felony treason and received emoluments to do it.
Well,
correct.
let's just play devil's advocate for a second and say, okay, now if the legislature has the authority to create corporations, and
where does it say that? Article 1, Section 8 is actually the delegations of a power, the limitations of power, the power that was actually delegated to the federal government and or the states.
Now, the legislature has the authority to act laws that, as long as they don't
as long as they are consistent with this Constitution, they have to be consistent with the Constitution. Not act outside the delegation of authority that we, the people, delegated and ordained and established as law.
So is there anything in the Constitution that says, hey, the Congress could not create their own corporation? Because I don't see where it says they can't.
It has to be properly delegated in order for them to do it. If it's not listed, see, that's what the 10th Amendment says. Only what's been delegated is the only powers you have. You don't have
correct.
Not delegated. That's why the Constitution is a limiting contract. It limits the power.
Yes.
What is specifically written in the contract is the only power you have. If the contract doesn't list it, that power doesn't exist. And you can't claim that, oh, well, it doesn't say that I don't have the power. You're right. It only says the powers you do have. So show me the power that was delegated to you. And if you can't show me, that's what a writ of quo warranto does. Show me by what warrant, by what authority you're acting. And you have to go to the law, the rule of law, and show me in writing what it says. And if you can't show me that it says that you have this delegation of authority, you just usurped the Constitution and acted arbitrarily, and you received emoluments to do it, which means it's an unjust enrichment and an emoluments violation. That's
right, and the maxim of law that applies is actus repugnans non potest in este producti. A repugnant act cannot be brought into being, that is, cannot be made effectual. But that's exactly what they did.
Right. So this is where we have to understand how government, we lost Brian. This is where we have to understand how government was formed and what our form of government actually is and what it means. Because if you don't understand how government is supposed to work, you're not going to understand what we're talking about here. The proper delegation of authority comes from constitutional law, okay? Constitutional law says you don't have this authority. So if you don't have this authority and you can't prove your proper delegation of authority to do and act the way that you're acting, that's an usurpation of power.
And if you get paid for that, that's an emolument.
Exactly.
Right? An unjust enrichment, 18 U.S.C. subsection 643, mismanagement of public funds.
And that, like Chris just said, that's actually, okay, Because emoluments is in the Constitution, the federal government has the power to create statutory law that provides the punishment. Okay, listen carefully. The punishment for violating the supreme law of the land. Okay, so Title 18, Section 643. There's a 634.
643.
643. Title 18, Section 643 of the United States Code, okay, codifying the law. That is a lawful code because it's providing the punishment for receiving emoluments violations. That's how statutory law is supposed to work.
Correct. And because that is not defined in state law, I have written a secondary challenge that says that because it's defined in federal law, both the states of Ohio and the states of Florida are not compliant within the terms and conditions of their contract, their state's constitution, to be admitted into the Republic of the United States. So until they define what constitutes an emoluments violation, they are deficient in their terms and conditions of that contract. It's that simple.
Right. You must follow the terms and conditions of the contract. And the contract is Article 6, Clause 3. Every single person, from the legislative branch, the executive branch, okay, the senators and representatives before mentioned, and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, okay? Every single one. If you're in the legislative branch, if you're in the executive branch, or you're in the judicial branch, you shall be bound by oath or affirmation to support this Constitution. Yeah, here's the, but no religious test shall ever be required as a qualification to any office of public, or is it office or public trust under the United States. So it doesn't matter where you're at, if you're an agent of any of those three branches. See, this is hierarchy. So the legislative branch creates the agency. We, the people, create the agency. Okay, that falls under the executive branch. Now, the executive branch has, according to the statutory law, they give the agency the authority to promulgate their rules and policies. But then this is where the prohibition on improper guidance documents comes into play, because you can't act outside the rule of law. You cannot promulgate these rules and policies that are outside of the delegated of authority. You think that you have this authority. That's acting under color of authority, creating these rules and policies that are in violation of the rule of law. You don't have that authority. All right, so let's continue rolling the video because there's more stuff here.
Those who ignore this duty and seek to advance their own policy views erode the entire rule of law. They set bad precedents and, importantly, undermine public respect that's necessary for the courts to function properly. An increasing number of district courts are taking the dramatic step of issuing nationwide injunctions, orders that block the entire United States government from enforcing a statute or an executive branch policy or order nationwide. Scholars have not found a single example of any judge issuing this type of extreme remedy before the 1960s. Never contemplated, apparently, by our founders. But today, in effect, single judges are making themselves super legislatures for the entire United States. We have nearly 600 federal judges, district judges in America, each one with the ability to issue an overreaching nationwide executive order eroding the power of the President of the United States, for example. So the Supreme Court is consistently and repeatedly made clear that courts should limit relief to the parties before them. So if lower courts continue to ignore that precedent, then the Supreme Court should send them that message again. And joining the entire federal government is an extreme, dramatic step. To take that step because of a political agreement would absolutely be unacceptable. The Constitution gives judges no right to veto a president's actions because they disagree with him on policy grounds. So the media, by the way, let me know, only focuses, it seems, on decisions that go against the Department of Justice. But we also have some important wins. The Supreme Court has vacated both of the appellate court rulings against the president's travel pause. They're taking it on the merits, but they vacated the injunctions. We've also successfully obtained before the Second Circuit a rare mandamus order staying a premature and abusive discovery order in a case to stop the wind down of the DACA program. Just an overreach. And I don't know how many times you've seen a mandamus on discovery be granted, but this one was, and we appreciate the appellate court for doing so. And so, although some district courts have initially ruled against us, I'm confident our positions will be vindicated in the Court of Appeals and, if necessary, in the Supreme Court. The President Trump has the statutory authority to suspend immigration in the law of any individual or group of individuals he deems are contrary to the national interest. His rational, narrow proclamation of a pause from certain countries that are dysfunctional and provide risk is justified within his powers as the chief executive who has the responsibility to protect the public interest, and we're proud to vigorously defend it. So before I conclude, let me say this. There are those in this room, and maybe more than a few in this room, who get frustrated about when they turn on the TV at night, and you have to take Rolaids, and everybody's got an opinion about what the Attorney General should do or what somebody else should do. Well, I get frustrated too. A lot of things I'd like to be able to say and explain, but the rule of law isn't always about getting the outcome you seek. It's using the same fair process, pursuing the truth wherever it leads. We can never allow any part of our legal system, and least of all the Department of Justice, to be reduced to a tool for a political agenda. This department will not make decisions based on politics, ideology, bias, as long as I'm Attorney General. I believe that this is what the American people expect.
Okay, so again, people like to keep construing what I'm doing here is about family law. This is not about family law, folks. I'm not about family law. I'm about the rule of law, America. Okay? You folks need to get it through your head. I'm about America and law. That's why it's Kirk's Law Corner. This isn't Kirk's Family Law Corner. Okay? Stop with the family law reform stuff. This is about the rule of law, and it applies to family law, yes, but it applies to everything, not just family law. Stop trying to make everything about family law. It's not just about family law. This is actually a world epidemic. I've talked to people in Australia, New Zealand, England. It's all around the world, folks. But we the people here in this United States of America have all political power is inherent in the people. Start acting like it. Start doing something about it. Okay? Right there. There's the video. I'm going to post this Office of the Attorney General's PDF. It's the memorandum for all components. Okay? Subject matter is prohibition on improper guidance documents. It's basically essentially the agency itself promulgating their own rules and policies and applying that to their agents of that agency, which is in violation of, imagine that, the rule of law. You're not allowed, there's no proper delegation of authority to promulgate your guidance documents to subvert the law. And that is ended as of yesterday, November 16th, 2017. You're done. So Bureau of Land Management, creating your own policies and then imposing those policies upon the people, saying, well, you have to pay these fees. You have to pay these fees. No, these are rights, and you don't have the right to convert that into a privilege, license it, and attach fees to it. That's the rule of law. You don't have that power. Just because your policy under your guidance documents, your policies for your agency, you cannot subvert the law. So when these people have water rights, and in order to get access to their water rights, they have the right to the access to the land and the use of the land. Okay? People don't understand how ranching works and how water rights work on, public land, because it is public land. This isn't government land. Neither is it, it's not federal government land, and it's not even state government land. It's public land. Okay? So, like with the Bundys, that land had been actually in their family for well over 100 years, long before BLM was ever created. So how do you suppose that an agency created in our government and then promulgated these guidance documents telling their agents of BLM that they can go do this and tell the people that they have to sign this contract, that you're going to pay these fees to have access to your rights? We've converted your rights into privileges, and you can exercise your privileges under this contract if you pay these fees. That's not how the rule of law works. You don't have that proper delegation of authority to do that. That's an usurpation of power.
But they did that with the driver's license.
Right.
I mean, they do that with everything. A license in Black's Law means a permission to do something that is otherwise illegal. Tell me when it became illegal to get married, to travel, to...
Bingo.
Yeah, it didn't. Yeah. We decided via contract that we needed permission to do all these things that we have rights to do.
Well, remember, the intended purpose of that licensure when it was created was to maintain the roadways, right? Well, they have usurped and misapplied the intended purpose of that particular rule of law, right?
Actually, hold on. Actually, no. The originally intended purpose was those that were engaged in interstate commerce.
Interstate commerce.
Okay, that is a federally regulated position.
Yes,
and
it
yes,
is.
the federal government has the right to regulate interstate commerce.
Between the state and another state, and between foreign country and this country. That's the only two proper delegations of authority.
So that was where the driver's license was created. But because people in government says, ooh, we have us a cash cow, let's tell the people they need a license.
Yes.
Right, and we'll call those roads state roads instead of interstate roads. See the difference?
Right. So exactly what Brian is doing right now. He is actually driving. He is a driver, one who is employed to operate a motor vehicle for hire. And that is exactly what Black's Law Dictionary says under license. It says streets and highways.
And here's
for hire.
And here's the view from my seat.
Right? So let me read it right straight out of Black's Law Dictionary. License, streets and highways, a permit to use street and a mere license revocable at pleasure. The privilege of using the streets and highways by the operation thereon of motor carriers for hire can be acquired only by permission or licensed from the state or its political subdivision. For hire, not for personal, private matters. Going to the grocery store, going to your mom's house, going to your friend's house, going dirt bike riding, going camping, going fishing, going hunting. All of those things is the right to travel. And I'm going to break it down even further. It is the right of liberty, and it is the right of property. Personal liberty consists in the power of locomotion. Choo-choo, vroom, vroom. The power of locomotion. And then property.
Again,
yeah, choo-choo. I do the choo-choo because that's my son. He loves trains. And
love it.
He, the property part is we have the right to acquire, possess, and utilize our property as we see fit. So you combine the two, okay? And the streets and highways are free for public use. That's public property, okay?
Hold on.
The reason why we license, the reason why
you're being vague. Clarify one word to that way everyone knows what it means. What is property? Because everybody's
I'm actually talking about personal
that
property.
word to mean something. No, stop. Don't put a description with it. You diminish the power of it.
Right.
Okay. The word property under 63C in AmJur 2D for general definition is your rights
Correct.
and interest,
Correct.
not the phone, not the car, not the house. It is the rights and interests that revolve around those objects. It's not the objects themselves.
And that's why children are technically your property. It's not necessarily the child as property, it's your parental right to the property. But going underneath those rights and all that, the personal property, the right to acquire, possess, and utilize your personal property, your automobile. It is not a motor vehicle. It is an automobile. And I have a crap ton of case law that says there's a difference between a motor vehicle and an automobile. So what Brian is doing, he is operating a motor vehicle. Driver is one who is employed to operate a motor vehicle. A traveler is one who is exercising his right of liberty, his property rights, liberty as a property right, and he's also exercising his right to personal property to utilize his personal property, his automobile. So there's a clear distinction between a motor vehicle and an automobile. Two different things. Now back to the using the streets and highways are free to the public to use. The only way it's not free, which I just read from Black's Law Dictionary, 6th edition, is when you are acting in commerce for hire. That is not for private purposes, and that is what destroys the roads. You know, you're running down the road with an 80,000-pound load. That's what tears up the road. So what we said was, okay, if you're going to act in commerce and you're going to be using the road for other than ordinary purposes, which is for the people to travel from place to place uninhibited by statutes, rules, and regulation, you're going to have to pay for the destruction of the road so we can fix it after you break it.
And that's what the fuel tax is for.
Commercial vehicles. That's how you pay for the destruction of the streets and highways.
Yeah, that's where that's what the fuel tax is for. Under the federal regulations, companies subscribe. The states subscribe to what's called IFTA. Not all states. Almost all states do. So however many miles you run in each state, every truck that runs through that state has to pay so much per mile. If they don't get enough fuel to pay for it that way, they have to pay. If they get too much fuel, they get a return, but usually what happens is that return goes to another state. And so that's how the federal government pays the states for maintaining the highways, but they don't exactly use it properly, as we all know.
So it sounds like we need to do an audit. But here's another.
Now, have you looked up a case? Yeah, have you looked up a case called Hendrick versus Maryland?
I don't think so.
It's very informative on this subject of interstate commerce. This was in, let's see, 1915. Because we know we've had automobiles for a while, but he just filed under the 14th Amendment and discrimination, stuff like that, against Maryland. And they talk extensively about that, the application of the interstate commerce and the reason you have to have a license and this, that, and the other.
Well, I just go to Hale versus Hinkle. I'm not obligated to divulge my private business to anyone at any time.
Now, I was looking at trying to find that case so I could tell you the right one, and I run across something fairly interesting. U.S. versus Anthony. I'm wondering if this is the same Susan B. Anthony. That's a good case to read.
Just so you know, folks, Brian actually does quite a bit of research, like I have done. He's only, what, have you been at it for a few years now?
About 5.5.
Okay, so there's definitely some things that he has read that I haven't read yet. Like I said,
yes.
There's way too much out there for everyone to know. When you're talking about American jurisprudence, there's like 40 or 50 volumes now.
Oh, and me and Kirk do not agree on everything. We agree on most everything. And our disagreements are actually, I love them, because he's got his knowledge based on what he's read. I got my knowledge based on what I read.
Mm-hmm.
We try to meet in the middle somewhere.
Right. It basically just you just have to read what it says, and this is what's called arguing. Okay, there's a difference between fighting and arguing. So in court, we make our arguments. We grab the law, we make our arguments, and the judge is supposed to determine facts of law. Now, is this a fact of law or is it not? So the jury is supposed to determine facts of evidence and facts of guilt. That's it. So there's a separation of power there. And that's part of the problem here, is through this making statutory law and allowing the judicial branch to subvert the law and provide rules of procedure based on statutory law that says you no longer have the right to a trial by jury. I don't think so. And I'm going to have to dig into this a little more to see if I can find where I can squeeze that in and construe, because that's arguing, making my arguments. I'm construing what this part here is that the statute is unlawful. It creates an unlawful jurisdiction. And then the judicial branch is actually, trying to make rules of procedure regarding that jurisdiction created by statutory law. That's all acting under color of law. Because even though the statute is in form of a law and it appears to look like law, and it's being put out there, well, this is what the law says, this is what the law, no, that's what your statute says. Now show me the law that you're codifying.
I keep hearing about this case, supposedly by the U.S. Supreme Court. You may know where it's at. I keep hearing about it, and at the time people talk about it, I am not in a position to write it down. Supposedly the Supreme Court, there was a case where they stated that statutes, codes, rules, and regulations are not law.
Oh, yeah. Yeah, I have a few.
And I cannot find those.
I actually have an Idaho case. I'll have to go pull it up. But, Idaho Supreme Court specifically says Idaho code is not the law.
Mm-hmm. Well, when you find those, will you send those to me?
Sure can.
Did you see those documents I sent you yet? You know you're busy like I am.
Shoot, I don't think I have.
I found it. One of them was a definition of what is securities, and there was a word and a phrase in that definition of security that was real eye-opening. I started talking about it last time when I got interrupted by a phone call.
Okay, so I kind of want to put this out there again. Please, people, stop adding me to your groups. If you want my information, you come here. I cannot keep up with 50 freaking groups that I've been added to. Okay? There's no freaking way. There's not enough time in a day for me to even go to these groups. And I've been slowly removing myself from all these groups. Okay? I'm here. You come to me. I'm not going to come to you. If you want to come to me and I post something, you share that to your group. Okay? Don't add me to your group expecting me to come into your group and preach to you in your group individually. Come to me, take my information to your group. That's how that works.
Well, now,
no way I can keep up with all of the groups. No way. Impossible.
People like me and Kirk, our job is to point you in the right direction. We can't lead people by the hands. There's no way. We have to show you where to look, teach you how to read, because people don't realize they don't know how to read. Because I didn't know how to read. I could pick up a book, a novel, and read it, and thought that was knowing how to read. But when you're messing with law, it's a totally different animal, and you've got to learn how to read.
Well, there's what you're talking about is reading is as opposed to reading, interpreting, and comprehending, because all of those three things go together.
Mm-hmm. See, I don't even agree with the whole analogy since you said it. Interpreting the law. The law doesn't need interpreting. That's why, because one of the things that I learned early in studying was the void for vagueness doctrine. It has to be written to where the common man, and we are all common men and women, can understand it. If it's not written in that way, then it is unconstitutional because it's void for vagueness and unenforceable.
That's actually in my Idaho Constitution. Unity of subject and title without technical terms is the next one. Okay.
That is a due process clause. That is a due process violation if they try to enforce it and it can't be understood. So there doesn't need to be any interpreting. The law, as you said, and I said, is not the statutes, codes, and rules and regulations. It's one of the reasons I love Westlaw. Is what I learned is what is the law? The law is supposedly, I would even argue under philosophy of law against this, but I can go with it. The bills that were passed and signed into law is the law. You don't see that. You see they will take those bills and then they will codify them. So you never see the whole bill. So when the courts go look at a law, they're going to see the bills, they're going to see the codes, they're going to see everything. So when the court interprets it, you don't realize they're mandated to follow what that bill was passed and said.
Okay.
When the words are defined and everything.
That's exactly what this show today is about. And because we went over the Jeff Sessions deal here, and there is no authority to do that. Okay, the rule of law, like Jeff Sessions says, and which I've been saying for a long time, is the law says what it says, and the Justice Department is supposed to uphold it exactly as it is written. And back to American jurisprudence that I put out yesterday, Brian, is that in constitutional law, when you're talking about common law, the rights, the bills of rights, those rights have the full force and effect of what it says, period. So it has to be followed as it is written. So,
and applied as it's written, by the way, because
yes.
remember,
right,
the law, basically justice, or law is the science of what is good and just, right? So, yeah, I mean, take and apply a scientific principle to your argument, because that's a maxim of law.
Well,
he keeps going in and out.
Yeah, he keeps cutting out. But yeah, I'm welcoming more people like Brian and Chris and myself to be part of what we the people have going on here. Glenina Zeiderfeld, she's running for a House seat in Idaho here. I'm trying to help educate her. Christy Zito. Actually, I'm going to have Christy Zito come on. I don't know exactly what night yet, but I spoke with her last night, and she would like to come on. So I'd like to promote her running for. She's already a House representative. Okay, she's already a member of Congress. She's a legislator for the state of Idaho, one of the many. So, and she's a liberty-minded person. And these are the kind of people that I would like to gather. People that are knowledgeable on the law or are willing to learn what the law says and make a stand. What was that?
Sorry, that was me.
Oh, okay. Sorry. So, yes, I see Joe Broliak has joined us. So, yes, I would definitely like to hook up with people like Joe, who are knowledgeable on the law. We need to work together. We need to come together. We need to speak the law. We need to start holding these people accountable. Okay, and with exactly what I'm putting out today, from the Attorney General from the United States of America is imposing the rule of law. It says what it says, and it doesn't say what it doesn't say.
Now, since I missed it, clarify something for me, because now I got a thought process. I'll get to it. What did he say they couldn't do?
Subvert the law?
Okay. Give me an example of what was going on at that time.
Well, let me read you the document here that he put out yesterday. This is from the Attorney General, Washington, D.C., November 16th, 2017. Memorandum for all components from the Attorney General. The subject is Prohibition on Improper Guidance Documents. And what this, I'll just read it. The Department of Justice has the duty to uphold the laws of the United States and to ensure the fair and impartial administration of justice. Therefore, when the department engages in regulatory activity, it should model the lawful exercise of regulatory power. In promulgating regulations, the department must abide by the constitutional principles and follow the rules imposed by Congress and the President. The principles and rules include the fundamental requirements that agencies regulate only within the authority delegated to them by Congress. They also include the Administrative Procedure Act requirement to use, in most cases, notice and comment rulemaking when purporting to create rights or obligations binding on members of the public or the agency. Not only is notice and comment rulemaking generally required by law, but it has the benefit of availing agencies of more complete information about proposed rules, effects, than the agency could ascertain on its own, and therefore results in better decision-making by regulators. Back to Title 74, Section 201. The people of the state of Idaho do not yield their sovereignty to the agencies so created. And in the formation of public policy, it is the policy of the state to have open meetings. They're required to have hearings. And this was what Jeff Sessions said. They're required to have hearings so that the public can be well informed of what's going on, and they're supposed to be able to vote whether that is going to be passed or not. They're supposed to be able to be heard and object to this bill or this policy being made because it is unlawful. If it's unlawful, it can't be done. The agencies are creating these improper guidance documents, even acting outside the statutory, under the legislative intent, because this is the part where we go back to not yielding our sovereignty to the agencies so created. Okay, the sovereignty we're talking about is the supreme law of the land, or the Constitution for the state of Idaho. That's the sovereignty, okay? Not sovereign citizens stuff. Sovereignty is declarations of independence. Sovereignty is the Constitution for the state of Idaho. Okay, so I don't know what happened there. It's all blurry.
Oh, that's weird.
So, yeah, the rule of law has just been smacked down. Jeff Sessions, the Attorney General for the United States of America, just smacks down that rule of law. As of yesterday,
with feeling, Kirk, with feeling.
Right. It's prohibition on improper guidance documents. And this goes back to what I posted earlier yesterday morning about, this executive order from Trump back in March, that to do basically an audit for 180 days, he was supposed to be listening to the people, and the people were supposed to get in touch with these heads of the agencies, and then these people were supposed to give a response to our federal government and say, this is what's going on. This is unlawful. These improperly guidance documents that have been created and the policies by these agencies are unlawful. And so this is part of things that are going to be abolished. And then what do you know? Lo and behold, I find this video last night before going to bed, and it just coincides with exactly what I put out there, that things are going to be changing. And apparently, Jeff Sessions says, I'm not waiting, I'm doing it now.
Yeah, those improper guidance documents is what's affected my family. But
Correct.
The reason I was asking that question was it hit me in the face one day. I've been a Christian for a long time, and studying law has taught me more about what the Bible says, because it hit me one day. People don't know what law is because they don't know who the lawgiver is. Who is the lawgiver? Man cannot give law. They cannot give rights. They cannot take away rights. All man can create is statutes, codes, rules, and regulations. They can call them law all day long. That don't make them law. They need your consent. They need you to contract.
Correct. So here's the problem with that is the need us to contract. In 1845, they extended admiralty jurisdiction back onto the land through Congressional Act, which is completely unlawful. So every single congressman who voted to enact that committed capital felony treason by extending admiralty jurisdiction back onto the land and allowing maritime law, the law of the sea, the law of contracts, to create the birth certificate, the social security number, your driver's license. All of that stuff binds us to these statutory jurisdictions that they have created, including the Uniform Commercial Code.
But you're allowed to rescind at any time.
Well, see, why do you don't have to rescind a fraudulent contract. If it's based on fraud, it's fraud from its inception. It's null and void from its inception. Marbury versus Madison.
Well,
and actually, when you're talking about enrichment, Schumacher versus Schumacher.
Well,
the contract is not so much voidable as it is void.
Bingo, it's void.
Technically speaking, they actually did not commit fraud. They disclosed it all. It's our fault. We don't read.
Well, no. It's still fraud because there's no authority to convert unalienable or unalienable creator-endowed rights into a privilege, license it, and attach a fee to it.
Hold on.
There's no authority to do that.
Hey, hold on. Slaves were never allowed throughout history to have an education, right? Why do you think they're dumbing down our children in the schools? They're teaching the kids to not read. So when they become adults, they become obedient, servants or slaves
Right.
to the system.
This is just the way it is. We've been doing it like this for 95
it's
years.
not
It's just the way it is. No.
Yeah.
That's not what the rule of law says.
It's not government's fault. It's not government's fault per se because they publish everything. It's our fault. I'm 44 years old. I didn't start reading this stuff till 5.5 years ago. I did not know I was ignorant.
Right.
And so whose fault is it that the fraud happened? They published everything. We didn't read it.
Yep. Self-governance, right?
That's right. Self-governance.
That's what it's
is the
supposed to be.
role of the federal government? One of the delegated authorities the federal government has is to protect the public. If you're going to be part of the public through those contracts, then guess what? You decided to let them be daddy. If they have to put you in jail to protect you, guess what? They will put you in jail.
Mm-hmm. Yep. But you have to know how to effectively claim your rights and defend your rights. You have to know what the law says. And if you don't know what the law says, you're screwed.
Those that don't know their rights
at the whim of the people who are telling you what it says. And this is the problem I have with attorneys trying to tell us, and judges are trying to tell us what the law says. And then they go to the statutes. Or half the time, you get attorneys, a couple of one recently who keeps trying to tell me what it says, but he won't produce what he claims it says.
Go back to slavery.
I produce the law that says something totally different than what he's claiming it says. Even statutory law says something different than what he's claiming it says.
Yeah. Now go back to slavery. Slaveries, like I said, were never allowed to have an education. They were never allowed to sign contracts or own property. They were not allowed to speak for themselves. Why do you think they want you to have an attorney? They don't want you to know the law. They don't want you to sign your own contracts. They don't want you to speak for yourself.
Yep. They don't want you to know what the law says. They don't want you to know what your rights are. And they don't want you to speak, because that's the most important part. You have to speak it. The belligerent man gets his rights. The squeaky man gets the grease.
The Bible says there is power in your words.
Right.
With blessings or cursings come from that mouth. So that means what? If you don't know your rights, all you're going to do is curse yourself. If you know your rights and you speak them, you're going to bless yourself.
Correct. So when you're talking about what law applies, when you're talking about slavery, okay, let's talk about Lex Scribionia. That's a law of the late Republic abolishing the acquisition of predial servitudes through prescription. Now, what are these documents that Jeff Sessions just declared unlawful do? They violate Lex Scribionia law. That's the reason that he abolished them, right?
Yep.
That's the law he was able to apply to basically terminate the acquisition of predial servitudes through prescription, because that's exactly what they did. Exactly what they did. So, in essence,
they write their own statutes and create their own jurisdictions, which will take you back to the Declaration of Independence, which I was reading last night. And again this morning, okay? Where is it? For protecting them by mock trial from punishment for any murders which they should commit on the inhabitants of these states, okay? So when we file our claims against these police officers who pull you over and then bust out your window and drag you out of the car, haul you off to jail without a warrant, and we make our claims against them, they say, well, we've done an internal investigation and we found no wrong. No, I'm making my claims I have the right to take this man to a trial by jury. That's how due process of law works. Whether you're the moving party or the defending party, you still have the right to a trial by jury. The jury decides guilt and evidence. The judge decides facts of law. The fact of law is I have the right to make my claims against this man and seek damages as well as criminal punishment for the deprivation of rights. And that is a violation of my right to due process of law, or deprivation of my right to due process of law, to bring an action against this man. He's a man. He's acting outside of his proper delegation of authority, his moral duties under his job title, but he was hired in a position of public trust to perform these specific duties. Nowhere in there in that contract to perform these moral duties and ethical obligations under the law does it say you can subvert the law and deprive me of my Fourth Amendment, my Fifth Amendment, my Sixth Amendment rights, protected rights. These are not constitutional.
Actually,
these are only.
The Declaration of Independence covers what you're talking about very clear.
It does.
Last sentence, paragraph 1. The history of the present King of Great Britain is a history of repeated injuries and usurpations, all having in direct object the same establishment of an absolute tyranny over these states. To prove this, let facts be submitted to a candid world.
Right. So these are actually declared acts of a tyrant. I don't care if it's directed towards the king, but these are actual declared acts of tyranny. Okay, so when we read through these, which I did last night, I read through some of the important ones that they're just happening today for depriving us, in many cases, the benefits of a trial by jury. That's the reason why we have bills of attainder clause in Article 1, Section 9, and Section 10, both to the state and the federal government, not to create bills of attainder that deprive us of our right to a trial by jury.
Right.
But they do that all the time.
They do, but nobody challenges it. You have to challenge the jurisdiction you're getting objected to. Well, that's an unlawful jurisdiction.
Speeding tickets, family court, all these administrative courts, that's what they do. They tell you, oh, you don't have the right to a jury trial in this venue.
And that's where
that's what I said.
Go, what do you mean I don't have a right to a trial by jury? You're trying to deprive me of my life, my liberty, and my property, and I don't
have no evidence.
Defend myself,
right? Right. Yeah. With not only no evidence,
jury of my peers, and let them decide.
Nothing more than a series of bullshit claims.
Right.
Right.
Where's your evidence to support your claims that gives you standing, the right to a cause of action?
Right.
Where's the
Can't bring it forward.
Where's the corpus delicti? And then you got to prove that I willfully intended to cause you injury and harm to make it criminal. Mens rea. Willfully intent.
I was recently asked what was one of the things that got the judge's attention in my most recent my most recent cause of action. And, basically it's number 19 was the one that got this judge's attention. There is no greater attack on our sovereignty than assaults upon our courts by bad lawyers and bad case law. It is for this reason I have accepted my responsibility to serve and be judged as intended by our forefathers and our founding documents. This case is what loss prevention under Article 1, Section 9, Clause 8 was written to construct. Right? Mm-hmm. So, when it comes to what, as far as my practice is concerned, now when there's no need for it, I'll put it down. I'll put it aside. Mm-hmm. But right now, there's a need for it. And I'm going to do it under executive order, as I've stated, as long as there's a need for it.
Now, what do you do?
Well, I'm an independent practice, registered and commissioned through the state of Florida to practice loss prevention principles and practices in federal court.
Nice.
That's my purpose. That's what I do.
It's called E-Clause, trademark, registered trademark corporation.
I might have to contact you sometime. I'd like to know more.
Yeah, that's
I built out the loss prevention department from my corporation that I used to work for, and built my own company around it.
What's going on over there?
Huh?
I said that's what happened to me. Is when I heard about what Chris Hallett, what he's doing, I'm like, wait a minute, I want to check this guy out. I want to see what he's got going on over there. Man, this sounds like some pretty interesting stuff. And what's he talking about? Emoluments? Emoluments? That's what I used to do. It's emoluments.
Well, me, I'm a truck driver by trade. I've been doing this for 14 and a half years. And when I got into this 5.5 year battle that me and my family's been torn apart over, we're still together, just we can't be together. I've done my best to study law. I did it just like everybody else does it. They go online, look up statutes, codes, rules, regulations, think they're studying law, and they go read cases and all that stuff. And I finally got to where I said, enough of this. We can afford it. I'm self-employed. I went and got Westlaw. So now I pay for Westlaw, so that way when I got a clear enough head from driving all week, I actually sit down and read and see what all is in Westlaw. You never know what I'm going to find. I found a lot of interesting stuff.
Oh, yeah.
Well, ironically, one of my credentials that I hold is a license to practice in real estate. And as it turns out, the fiduciary practice of real estate is mirrored the intended purpose of the fiduciary practice of law. And one of the things that we, part of agency practice is if you're a dual agent, your duty becomes to the contract once you have a contract, right? So if you start this thing as a seller's agent and you bring a buyer, now you're a dual agent. Once you've got offer and acceptance and a contract, even though my listing agreement was with the seller, guess what? My fiduciary duty is now to the contract to make sure the integrity of that contract is maintained throughout the transaction, right? So when you're talking about
the law,
right?
Well, it makes the transaction, right? So when you talk about causes of action, transaction, occurrence, or event, right? So, like I said, I drew the parallels, and the court said, "Okay, yeah, you're absolutely right." So, what have you got to show us that we have never seen? And I said, "Well, how about this?" And they went, "Where is that?" And I said, "Article 1, Section 9, Clause 8." And they went, "Wait, what?" They said, "Well, what is it to you?" I said, "To me, it's loss prevention. That's the you're fired clause, right? The means for the people to limit their government. When actors in government violate their oaths of office, we have the right to fire them, right? And because nobody's ever tested it, right? Ironically, they elected the guy whose favorite words are "you're fired." So I said, okay, well, we do policies and, we write policies and, trash policies all day, every day for the sole purpose of maintaining the integrity of our corporations or our contracts, whatever the thing is that comes across my desk when I was actually working in loss prevention. So, this is no different. These documents, these agency documents that Jeff Sessions just basically terminated. He took a page out of my playbook and said, "Hey, this is loss prevention. Terminate this crap. It's bad policy."
So we got some actual bullet points here, and I'd like to go over those from this letter from Jeff Sessions. Number 1, guidance documents should identify themselves as guidance, disclaim any force or effect of law, and avoid language suggesting that the public has obligations that go beyond those set forth in the applicable statutes or legislative rules. Number 2, guidance documents should clearly state that they are not final agency actions, have no legally binding effect on persons or entities outside the federal government, and may be rescinded or modified in the department's complete discretion. Number 3, guidance documents should not be used for the purpose of coercing persons or entities outside the federal government into taking any action or refraining from taking any action beyond what is required by the terms of the applicable statute or regulation. Number 4, guidance documents should not use mandatory language such as shall, must, required, or requirement to direct parties outside the federal government to take or refrain from taking action, except when restating, with citations to statutes, regulations, or binding judicial precedent, clear mandates contained in a statute. Here we go. Statutes or regulation. In all cases, guidance documents should clearly identify the underlying law that they are explaining. Number 5, to the extent guidance documents set out voluntary standards, e.g., recommended practices, they should clearly state that the compliance with those standards is voluntary and that non-compliance will not, in itself, result in any enforcement action. Period. Okay? Those are five separate bullet points there that's in this letter from Jeff Sessions. Pretty straightforward there.
Do you want to watch the rest of it, or is it pretty much done?
Yeah, I think we want to thank people for tuning in. Like, follow Kirk's Law Corner if you enjoyed the show today. There's going to be more of this stuff coming out. I'm going to become more active, more education. We'll do Law for Dummies on Monday nights, but there's going to be more of this where we just pop on live with breaking news or, something that's happening out there that we would like to discuss and help educate the people on how to defend themselves in any manner in accordance with the rule of law. So,
do you want to watch the rest of this video? There's a little bit more.
Go ahead and play the rest. I don't think there's much left of that.
There's like
actually.
two minutes left, but what I can do is I'll pull the video off of here and then I'll post it directly on Kirk's Law Corner, so it'll just be
It's already on Kirk's Law Corner. I posted it. I posted it last night.
Cool. All right. Well, here's the rest of it.
I think this is what the American people expect and deserve from the Department of Justice. And we will not confirm investigations or leak sensitive law enforcement information to get a few cheap headlines. I am determined, we are determined as a team in the Department of Justice to reestablish proper discipline in these matters that has been eroded. I got my page out of line. You have to come back to that. So in the long run, a failure to fulfill this responsibility can only result, it can only result in a perpetuation and a further decline in respect for justice in America. When anybody asks us to investigate a crime, we will take that seriously. That's part of our duty. We consult with the appropriate law enforcement agencies. We evaluate the evidence. We use our best judgment to make an appropriate decision. And recusals, well, recusals happen all the time throughout the Department of Justice and in private practice, just because we follow the rules. That furthers confidence in justice, doesn't erode it. So I believe that when the history is written about this department, it will reflect that President Trump appointed one of the finest teams ever assembled in the Department of Justice. the man at the top, not in the group, and that we remain faithful to his charge and our oaths. So I am so proud to work with you, to work with people like Leonard Leo, whose counsel and judgment I've always valued. I am proud to work every day with great people that we've selected, a lot of great career people also, and I'm proud to stand with you as we defend the rule of law in this great republic. Thank you so much.
The rule of law. Like I said, Jeff Sessions just put the smack down on the rule of law, and he just said, if somebody makes a complaint, and they're going to look into it. So let's start getting our claims out there. So let's start making these complaints, because that's what they want to hear from us. So, you know, call up the Department of Justice and say, hey, this is what happened to me. Jeff Sessions says that you're going to be investigating this.
And don't sound like the monster truck with your pedal to the floor. Clearly, concisely, calmly, right?
Right.
Very, very, very key thing to maintain.
Yeah, you know, just ride up there on your bicycle and ring your bell. Ching ching. Hey, I've got a complaint here.
There you go.
You know, instead of ripping up there in that monster truck 4x4 and my rights are being deprived, they're not going to listen to you.
Nope.
They're going to look at you like you're a freaking crazy animal that just came out of the woods, Appalachian Mountains. Yeah. Who in the hell is this caveman? He can't even control himself emotionally. He can't be clear and concise, so I can even understand the word he's saying, and dropping the F-bomb like Thomas, like Chris Allen said last night.
Yeah.
Thomas, come on. These people aren't going to want to listen to you. I'm not going to want to listen to you.
Nope.
So,
called being reasonable.
Right. Calm, clear, and concise. So,
right.
Again, thanks for tuning in, folks. We'll be back with more stuff. Have a wonderful day. Enjoy the new information. Garrett, put it out there. The rule of law is back.
Love you guys. We'll be talking to you on the next update.
Yep. Love you guys. Thanks, Chris.
Okay.
Thanks, Brian.
All right, man. See you later.
Thanks, Ted.
Thank you.